This lecture is the rights of copyright owners, and we'll cover several of the important rights that you have once you get a copyright in this lecture. So today's agenda is basically to go through a series of the important rights in copyright. And we start first with the right of reproduction. Look at the right to prepare derivative works, the right of distribution, and the public performance and display rights. As we'll find out, a lot of these rights, with perhaps the exception of the public performance and display rights, really do derive from the basic right of reproduction. But just as a quick overview, let's look at the list that we've looked at before, but just to refresh our recollection on the rights of the copyright owners. These are the basic rights you get as copyright owner. You get to reproduce, make derivative works, the right of distribution, performance and display, anti-circumvention, and moral rights in some cases. Those final two, the anti-circumvention and the moral rights, we're not going to cover very much at this point, but just wanted to flag them for you that they are generally considered some of the basic rights of copyright owners themselves. So let's look at the right of reproduction. The right of reproduction is also known as the right to make copies of copyrighted works. And what that means is you have the right to prevent other people from copying your work, your copyrighted work, and engaging in improper appropriation, right? So those two pieces, copying and improper appropriation, both have to be present in order for there to be a copyright infringement and an infringement of the reproduction right. One sort of thing to keep in mind is that both copying and improper appropriation use the standard of substantial similarity as the basic test, which can be somewhat confusing because courts will talk about substantial similarity in both contexts, but just be aware that those two elements, copying and improper appropriation, are both required. So looking at the cases, the Arnstein versus Porter case, the key question in Arnstein is whether or not Cole Porter copied some of Arnstein's works, the songs. The plaintiff alleges that the defendant's songs had been basically what he described as plagiarized from some of plaintiff's works that were relatively similar. Right? So the analysis here is important because the court is sorting through how to figure out what it means to copy a work. Right? And the defendant here, Cole Porter, says he did not copy it. He said he had no idea about these works, that these were not anything that he had copied and used, and so he said, he was not admitting to it. And so the question is, what do you have to do in order to find copying? And again, copying is a required element of copyright infringement. So if the defendant doesn't admit that he or she copied the work, which they might in some cases if they were going to argue fair use or some other defense, but if they were arguing they didn't in fact copy the work, then you have to show, the court holds in Arnstein, access plus substantial similarity. Right, so you can get you can see in the book, the copying, the evidence may consist of a defendant's admission or circumstantial evidence. In almost all cases, you're going to have circumstantial evidence, usually evidence of access. Right, so the question is whether or not you can infer copying from the fact of access to the work and substantial similarity. So you have to show access to the work plus some substantial similarity of the work that would then infer that what has happened in the case has been copying. Right? And the court then goes through and says, you have to look first at the substantial similarity to determine whether or not there's the possibility of a problem here. And how do you prove substantial similarity? Well, it's a case-by-case analysis. You're looking at the similarities between the two works, how closely related the work, the allegedly copying work is to the copied work, and that's basically the test. There's not a good sort of set of rules for that other than case-by-case analysis, and the court, as you can see, gets right down into the sort of the details of how this works. They say that they find some similarities, but they don't compel the conclusion because they're not quite the same, that they're identical. They're certainly similar, right? The other thing you have to show is access, right? And here the court says, well, there was testimony that there were, what Arnstein says is that stooges, what he described as stooges of Cole Porter, broke into his apartment and stole the works or copies of the works, which then allowed the plagiarism. Porter says that's ridiculous, and it seemed like the district court thought that was fantastic, not credible. What the appellate court here says is that although that testimony may be not particularly credible, the fact remains that more than 1 million copies of Arnstein's compositions were sold, which means they were in pretty wide distribution among the relevant community. Copies of others were sold or distributed to radio stations, and so that at least raises a triable issue of fact as to whether or not Cole Porter had access to Arnstein's works, right? And then once you get to the point that it is that there's access plus enough similarity to raise the inference of copying, then the court says then you move to step 2, which is whether the appropriation has been improper, and we'll talk about that in a moment. So the improper appropriation analysis is best shown in the Nichols case, right? And the Nichols case deals with a couple of plays, motion picture plays, that are different, but the plot lines are quite similar. And this is the question, right? The question that Nichols deals with, and it's one of the thorniest questions in copyright law, is that improper appropriation, the protection of copyright, expands beyond the literal text, right? It expands beyond the expression itself to something else, right? It's broader than simply verbatim copying, but how much, right? So it doesn't go too far, the court says over and over. And how far? Well, the test here, again, sort of confusingly, but it makes sense when you think about it, is substantial similarity, right? So the test for whether you have improperly appropriated somebody's copyrighted work is whether or not there is substantial similarity between the two works, right? And that is the key analysis for copyright infringement, right? And so, yes, protection expands beyond literal text, beyond the literal expression. How far? It expands as far as substantial similarity does. So the question here is, the specific question in Nichols is how much protection is given to the plot of a story itself. And the plot of a story, the court seems to say, is certainly copyrightable. However, the amount of copyright there is not particularly significant because of some of the doctrines, like the Senza-Fair doctrine, which limits your ability to use the building blocks of, in particular, plots and characters. And so there is protection to the plot of the story, but again, because of Senza-Fair, because of expression idea doctrine, you're not going to get a whole lot of copyright for the plot itself. Now, the characters can have more copyrightability if they are unique and distinctive. And here, the court says the only characters that it found were particularly similar between the two plays were what it described as stock characters, right? They were characters that you would see in virtually any work of dramatic fiction, and therefore no copyright or not very much copyright at all in that. Again, this idea that there's a very thin copyright when you are using materials that are largely unprotected. And so one of the things to think about when it comes to understanding the substantial similarity improper appropriation analysis is that really what's going on, I think, is a two-stage process, right? So first what you have to do is figure out what parts of the expression itself are the protectable elements. And we talked about this in some of our earlier lectures on copyright. So you have to figure out which pieces of expression, and in this case, in the Nichols case, the play, can actually be protected, right? So meaning you have to extract out stock characters, for example, sense of fair, any ideas that are embedded in there all have to be removed, and then what you're left with is the protectable elements, the expression, right? And then what you do is you compare those protectable elements to what's in the allegedly infringing work to see whether or not that expression, that protectable expression, is what is actually infringing. And if it's there, then you've got substantial similarity and improper appropriation. If what is in fact been taken is instead the unprotectable elements, then there has not been copyright infringement. It is not substantially similar, right? So I think it's easiest, although there's some debate about this in the academic community, but I think it's easiest to think about this in terms of a two-step process where you're sorting out, trying to figure out what is protectable, what are the elements of expression which are protectable under the Copyright Act, then take those elements, look in the allegedly infringing work, try and figure out whether those elements have show up in substantially similar form, and if they do, you've got copyright infringement. If you don't have copyright infringement. So how much of the copyrighted work must be taken for improper appropriation is itself a pretty interesting question, right? Most courts think that it is, in a sense, a sliding scale, which is it varies considerably by the strength of protection, right? So if you have a very thin copyright, so for example, if you have a character that is largely based on stock characters, then that amount of copyright would be quite thin. You could also think about this in terms of a fashion design, right? Since much of your fashion design might be functional in nature, the amount of copyright given to that is going to be quite thin. And so because of that, the strength of protection, or because your amount of copyright protection is thin, we're going to require that more of that expression be taken, that it be more literally copied than if you had something truly unique, something truly expressive, say a unique painting or something. There we would say that it doesn't have to be quite as similar, right? Or that the amount of the work that you take, the amount of the expression that you take doesn't have to be as much, right? So it's a sliding scale. Right? The stronger the protection, the more protectable the underlying work, the protectable elements are, the less we're going to require a lot of that or all of that to be taken. If, on the other hand, the work has very little, very thin copyright, then we're going to allow more of the work to be taken without finding copyright protection. Right? All right, so let's look at our second important right of a copyright owner, which is the right to prepare derivative works. And as we're going to see in a minute, this is a bit of a puzzle. The definition of derivative works is found in Section 101 of the Copyright Act, and it's a work based upon one or more pre-existing works. Can be a translation, an arrangement, a fictionalization, motion picture version, sound recording, a work consisting of editorial revisions, annotations, elaborations, or other modifications which as a whole represent an original work of authorship is a derivative work, right? So the idea here is that derivative works are based on and a pre-existing copyrighted work, but adds some sort of new expression, right? So it's and this right is given to the copyright owner as a matter of copyright law, right? So the big case here, the important case to look at here, is the Anderson versus Stallone case. In the Anderson versus Stallone case, the court makes three key findings. One is that the characters from Rocky 1 through 3 are copyrightable. The court says these are quite unique characters. The fact that they were primarily expressed in film doesn't matter. I guess that was a somewhat novel question under the law. So they're fully copyrightable. Anderson, in this case, of course, created a treatment for Rocky IV, right? A set of ideas, a 31-page basically overview of what he thought Rocky IV should be. This, the court says, is a derivative work because it used the characters from Rocky 1 through 3. So it was based on a pre-existing work, and therefore it was a derivative work under the copyright statute. The important aspect here, and perhaps the most sort of controversial aspect of this case, is the court then decides that none of Anderson's work is actually protectable. And so let's move through that. So let's talk first about what it means to be a derivative work, right? And what's the test for a derivative work? One of the interesting things about derivative works, and the reason I suggested at the outset that it was a bit of a puzzle, right, is that the definition of a derivative work is one that infringes the original copyright, right? So that has the benefit of being a nice simple test, right? So what's a derivative work? Well, it's a new work that infringes the original copyright, right? So that means it is substantially similar to the original copyrighted expression. That, however, creates a puzzle, as we're going to see, for why you would want, for example, to have derivative works as a separate and independent right. But we'll talk about that in a minute. So the analysis here is relatively straightforward because the question is whether or not Anderson's treatment, 31-page treatment, using and based heavily on the Rocky characters from Rocky 1 through 3, infringes the copyright of Stallone. The court holds that it does because it uses the copyrightable characters in a way that was unauthorized. Substantial similarity is present, therefore it's a derivative work. The more controversial holding here is that then the court goes on, because what Anderson says is, all right, so even if I've created in some sense a derivative work, some of my expression, my ideas, my treatment here is in fact my own. So I basically took some of Stallone's work, combined it with my own protectable expression, and therefore even if you extract away the pieces that I infringed, the pieces that Anderson took from Stallone, Anderson says I still have considerable amount of protectable expression available for copyright protection, right? And the court holds that none, because it's an unauthorized derivative work, none of the treatment can be protected, right? And they do this under the, basically an interpretation of the copyright statute, which under Section 103 The subject matter of copyright specified in Section 102 includes compilations and derivative works, but protection for a work employing pre-existing material in which copyright subsists does not extend to any part of the work in which the material has been used unlawfully, right? So Anderson says, well, that means that the rest of the work, right, the part that has not been used unlawfully, his own new material, is copyrightable. And the court disagrees, right? He says, the court decides that based on some legislative history, that in fact unauthorized derivative works get no protection whatsoever, so that there is no copyright in anything that Anderson did in his treatment, right? And this is a holding then, which means that Anderson, because he created a derivative work, because he used some of Stallone's pre-existing characters, created this treatment, then ends up with essentially no copyrighted expression at all in his treatment, because he mixed it with his own. Even though he mixed it with his own expression, he essentially loses his ability to protect that expression. Right? And so one question is, well, then what's the result of this case? Who owns the copyright in A's treatment? Well, the answer is there's no copyright in A's treatment, but of course, Stallone effectively controls it, right? Because it infringes Stallone's copyright in the characters, and because there's no copyright in it, Stallone is free to use it, but Stallone can also prevent anybody else from using it. So really, at the end of the day, you can say, in some sense, Stallone gets the derivative work, even though he didn't make it himself, right? So Anderson can't stop him from using any of Anderson's new expression, and Anderson doesn't have any copyright at all, and no one else can use the treatment because it is unprotectable under copyright. So the puzzling question, somewhat puzzling question here, is why, if a derivative work is the same thing as a infringing work, then why do we have a separately listed right, the right to prepare derivative works, and what work does it do? And it's a little unclear. It seems relatively clear that the intent is to provide additional incentives for copyright owners to make derivative works. Now, it's not clear why that's particularly necessary, since if derivative works are infringing works, then they have the incentive to do that anyway. It might be that the idea was to create situations to dissuade people who are not the authorized copyright owner from creating derivative works of their own. You can see how the Andersons of the world are now going to be relatively less inclined, actually much less inclined, to do this sort of thing after this case, after the holding of this case. And so then the question to ask yourself is whether that's the right balance, right? So if what it really is doing is essentially expanding, in a sense, the right of copyright owners, not so much to get new copyrights, but to prevent other people from creating follow-on works, then is that the kind of thing that copyright should be doing, or is it merely stifling additional competition, right? Because you could imagine, from a public policy perspective, saying we want to encourage people to make follow-on works, to create adaptations of pre-existing works, and so forth. But copyright law is so, because of the derivative work right, is pretty strongly tilted in favor of the copyright owners in these contexts. And so what you end up with is a situation where, although the derivative work right doesn't give a lot extra to copyright owners, it seems to largely dissuade people who might otherwise follow on with their own works from doing so. Okay, let's turn to the right to distribute next, and we won't spend a lot of time with this because the distribution right has an important limitation. So we basically think of the distribution right as the right to determine how copies of your work are distributed. The most important limitation of the distribution right is the first sale doctrine. And the first sale doctrine says that once you've sold a particular copy, say a book that's copyrighted, you no longer, as the copyright owner, have the right to control the disposition of that copy. Now, you can obviously, because of the right of reproduction, prevent people from making new copies, from making derivative works, from publicly performing or displaying the work, but what you can't do is prevent them from doing whatever they want with that work. And that can mean reselling the work, for example. That can mean destroying the work. That can mean defacing the work, and a whole variety of other things. So the first sale doctrine limits your right to distribute fairly significantly. And so what we think, the way to think about the distribution right is that what it really is a right of first distribution. So once you before you sell works, then it would give you, before you sell any works, but you've created copies under your authorization, it gives you the right to determine when things first get distributed. Obviously, once you actually sell them to people, then because of the first sale doctrine, you don't have control over it anymore, and that right for that work is essentially gone. But it still holds for works that have not yet been distributed, but copies have been created. So if you have stockpiles, for example, of books in a warehouse, if somebody started selling those, that would be copyright infringement under the right to distribute. Even though they're not making a new copy of the work, they are violating your right to distribute. If, however, you've sold those to a third party, say Amazon.com or something like that, then they are free to sell those as they want, and do anything they want with them, rent them, or etc. So that's the distribution right, which is really a right of first distribution. And finally, we get to the public performance and display rights. So the public performance and display rights under Section 101 are defined. To perform or display work publicly means to perform or display it at a place open to the public or at any place where a substantial number of persons outside of a normal circle of family and its social acquaintances is gathered, or to transmit or otherwise communicate a performance or display of the work to a place specified by Clause 1, or to the public by means of any device or process where the members of the public capable of receiving the performance receive it in the same place, separate places, and at the same time or at different times, right? So that's the definition of public performance. The idea here is that one of the rights that copyright owners get under the public performance display right is to determine how and when and under what circumstances a copyrighted work is performed, done publicly. And so that's an important right, especially when you're talking about, for example, TVs and movies, songs to some extent as well. The important thing here to understand are the definitional aspects, right? So public, what we mean by public, is the group that's beyond your social family or circle, right? So if you have a small party showing a football game, that's probably okay. If you invite lots of people you don't know, that's borderline. It's certainly if you are opening this to the public in some public fashion, advertising it or something, then it's definitely public, right? And so that's why public can also mean, it can mean a large group, it can also mean just one person if the same copy or set of copies is used over and over again, or if it's generally advertised, right? So this is the idea that viewing rooms in video stores, even though one person or a very small group at a time would use those viewing rooms, those nonetheless are public performances because they are open in some significant sense to the public. And note that for public performance and display, you don't have to prove that anybody's actually watching it, right? So it doesn't matter how many people are actually there. It just matters, or how many people could potentially be there. It just matters in some sense, in particular if you're talking about public in the sense of open to the public. It just matters that it's possible for members of the public to watch or the performance or see the display, right? The other thing to understand about the public performance and display right is that they are very important. There's a lot of limits on these public interest exceptions that the book goes through. There's a lot of them for education, for distance learning, for a variety, sort of almost a laundry list of things that Congress thought should be accepted from the public performance and display rights. There's also a series of compulsory licenses. These are not exceptions to the law. It just means that they have to pay a license fee and they get to do it, right? Meaning the copyright owner can't stop them from publicly performing, although the copyright owner does get money. The money is sometimes specified in the statute, sometimes determined by an administrative agency such as the Copyright Office. These are things like satellite and cable retransmission. Jukeboxes have a compulsory licensing scheme. Webcasting compulsory licensing scheme, and public broadcasting gets compulsory licensing schemes. Generally, these are thought to be advantageous for those parties that have them, because it means they don't have to engage in lengthy negotiations with content owners in order to do what they want to do with the content. But the content owner does get something in the sense that they get some return, some money from the copyright user in those cases, right? So public performance rights are anything that is performed or displayed, shown to the public. Again, public can either be a large group, people you don't know, or can be sort of advertised open to the public at large, even if only a small number or even none take actual advantage of it. And so that's it for this lecture on the rights of copyright owners.